Because I'm a board-certified civil trial lawyer, I'm generally the lawyer who will advise my client whether or not it's in their best interest to file suit on their case. As a specialist in civil trial law, I am comfortable trying cases when the insurance company or corporate defendants are not offering enough money to fairly settle your fall-down case. In every case, we hope to settle your case without having to file a lawsuit and force the defendants to pay fully and fairly. If you are in a situation where the at-fault defendants refuse to pay a fair settlement, you may have to decide if you want to file a lawsuit to recover your damages. However, before you decide whether you want to reject their offer to settle and file suit, it is important to understand there are some risks and benefits of filing a lawsuit. The first step in assessing the likelihood of winning your case is to consider the Florida comparative negligence law. Florida's comparative negligence law says that if a jury or judge finds any plaintiff more than 50% at fault, then their recovery is zero. This is why it is important to consider whether there is a risk of losing your case based upon this law. So how do you assess whether or not to file a suit for your damages after falling and being injured by the fall? Let's address the risk of filing a suit first. The risk of losing at trial and the jury finding you to be more than half at fault, that's one risk. Second, higher costs will be incurred by filing a lawsuit. 3, the exposure to fees and costs from the defense if you lose. Now, let's consider some of the benefits of filing suit. It may result in a higher settlement offer for your case. Filing suit will increase the level of decision makers evaluating your claim and exposing the truth of what the defendant did wrong that injured you. Now, let me go through each of these risks and benefits one at a time, starting with the risks. The risk of losing under the comparative negligence law gives the jury the job of comparing the degree of fault of anyone and everyone who may be at fault in any way for your fall. As your lawyer, you and I will argue the defendant was 100% at fault for your fall and injuries. And 99% of the time, the defense will argue that you were at fault too to some extent for falling and getting hurt. The defense may also say someone else, such as another customer or another business, or even the architect who designed the area where you fell, is to blame for your fall and your injuries and not them. The defense may also say that they had no way of knowing the dangerous condition that caused your fall was there, and therefore they could not warn you or anyone about that danger or even fix the danger before you fell. They will say that since they did not know of the dangerous condition, they should not be held responsible for something they could not fix or warn you about. If the jury finds you more than half at fault for the fall, you have lost your case. The defense has won, and you recover nothing. The risk of going to trial is something that must be seriously considered, because if the jury finds you more than 50% at fault, you lost your case. Now, the second risk of filing suit is the added cost of filing a lawsuit. It would be nice if every case could be settled for full and fair settlement without having to pay the expense of a court filing fee, process server fees, court reporter fees, expert witness fees, and to pay your doctors for their testimony. These are just a few of the added costs of filing a suit. The third risk of filing suit is the exposure of having to pay court costs and defense attorney's fees if you were to lose your case. If you decide to go all the way to trial and the jury returns a verdict in favor of the defense and you do not make a recovery, the judge may enter a judgment against you for some, but not all, of the costs that any of the defendants may have incurred in defending the case. But now let me talk about a tricky strategy that can be used by either side, which punishes a party to a lawsuit for not accepting a reasonable settlement. This is called an offer of settlement. The way an offer of settlement works is we, the plaintiff, can offer to settle your case for a certain amount of money. This offer has a few technicalities, but suffice it to say that once we send the offer of settlement, the defendant has 30 days to think about the offer, and if they wish to settle the case for the amount that we offered, then they accept the offer and your case is over. However, if they decide not to accept our offer of settlement and we go all the way to a jury trial, and the jury awards you 25% more than we offered to settle the case, then we tell the judge, we offered to settle this case for 25% less than the jury awarded, and therefore, because the defendant rejected our offer of settlement and forced us to go to trial, we should be paid our attorney's fees from the date of their offer, all the way through trial. Judges often award these attorney's fees in addition to the judgment as a sanction or a penalty against the non-settling defendant. However, the offer of judgment is a two-edged sword. The defendants may send you an offer of settlement, and when they do, you have 30 days to think about their offer. And if you decide not to accept their offer and we go to trial and the jury awards you less than 75% of the offer, you will quite likely owe the defendants their attorney's fees from the date they made the offer to you. This is an important consideration before filing a suit because it is quite possible that even though you are the plaintiff, you might possibly lose the case and owe the defendants money. Now, let me talk about the benefits of filing a lawsuit. First, the filing of a lawsuit offers the following motivations and reasons for the insurance company defendant to offer you full and fair compensation for your injuries. These motivations include insurance companies generally pay more to settle cases when they are exposed to the risk of losing at trial. Insurance companies pay more to avoid paying lawyers to defend the case. Insurance companies pay more to avoid paying expert witnesses to testify in the case. The number one biggest reason insurance companies pay more to you after you file a lawsuit is because the insurance company wants to verify the fault or liability of your fall, and they want to verify the seriousness of your injuries. Insurance companies generally doubt the defendant was at fault, and the insurance company seriously doubts that you are as injured as we told them that you were when we attempted to settle your case before filing a lawsuit. So what this means is the insurance company needs more proof of their fault and your damages before the adjuster can increase the offer to settle your case. By filing your lawsuit, the insurance adjuster can add notes and your medical records to their file, which allows them to justify to their supervisors why they are recommending paying a full and fair settlement, because they will be able to do so following once a lawsuit is filed. They can also obtain and review all of your medical records, employment records, and your medical bills. They will be able to take your statement in the form of a deposition to fully evaluate the facts of what happened and at the same time evaluate your credibility. They can obtain information from witnesses about what happened. With more information, it makes it easier for the adjuster to offer you a full and fair settlement. The insurance company also measures the skill and determination of your attorneys. When we file a lawsuit on your behalf, we are telling them that we are committed to winning your case, and if forced to go all the way to trial, we shall seek the full measure of justice on your behalf. Now, the second benefit of filing a lawsuit for your fall is your claim will have higher levels of money decision makers evaluating your claim. Once your lawsuit has been filed, your case gets the attention of higher and more experienced claims adjusters. Your claim goes up the ladder of the insurance company's hierarchy to adjusters with more settlement authority. Your case will be evaluated by their defense attorney. The defense attorney should have credibility with the insurance company because they're being paid by them to collect evidence and evaluate the risk and exposure of your claim. There is a caveat, though. The defense lawyer is giving advice to their clients about settlements, and that caveat is the lawyer's getting paid to work on your case. So the longer it takes, the more money the defense attorney makes. But the lawyer also knows that if the insurance company does not offer enough money to settle your case, that he or she will be forced to defend the case in trial in front of a jury, and with this lawyer now faces the risk of hurting their own credibility with the insurance company, because if they lose at trial and the jury awards more money than the lawyer suggested that they pay to the insurance company to settle your case, this hurts the attorney's reputation. The third benefit of filing a lawsuit is exposing the truth of what the defendant did wrong. Once we file a lawsuit, most of what we uncover through the discovery process becomes public knowledge. Most defendants do not want the public to know how badly they treat some of their customers. Quite often through litigation, we find out how bad the defendant and/or its employees are. The defendant does not want the public to find out the shortcuts the business took to maximize profits over the safety of their customers. Also, insurance companies have 3 conflicts of interest with their insured. These conflicts should motivate them to make a higher settlement offer. The first conflict is the insurance company's profitability. There's a conflict between the insurance saving money and increasing profits, or paying full and fair value and reducing profits. The second conflict of interest is the risk of exposing their insured to a future loss of business from the public's awareness of the defendant's negligence. And the third conflict of interest is an insurance company has the risk of your case recovering a judgment in excess of their policy limits. And when this happens, their insured may have to pay out of their pocket for a claim that could have and should have been settled. These risks and exposures insurance companies face are the motivations to require confidential settlement agreements. So now that I have discussed the risk and benefits of filing a lawsuit for your damages, let's talk about the reality of your case going all the way to a trial. It is relatively small. It's important to know that the chance of your case going all the way through a trial is slight. Ultimately, the best offer to settle your case usually comes right before or even in the middle of your trial. During the discovery phase of your lawsuit, and even after either side may file offers of settlements, most cases ultimately are settled before the jury renders a verdict. When a settlement is reached, all risk end. Instead of both sides facing a risk of losing at trial, a compromise is reached and each side pays their own costs and attorney's fees. So ultimately, the likelihood of you having to pay costs or attorney's fees of the defendant is slight. However, we have a duty to inform you and advise you of all the risk and all the benefits so you can make an informed decision of whether or not to file a lawsuit and not be surprised later. I hope you found this video helpful in understanding the advantages of filing a lawsuit and the disadvantages of taking a low pre-offer settlement. I encourage you also to watch my video about offers of judgment, where I explain this procedure in much greater detail. Thank you for watching my video. If you or a loved one have a serious injury or wrongful death case, please call me, Matt Powell, at 813-222-2222.